Good morning, Adab, Sat Sri Akal and Namaskar. This is another case which had come to me during the days when we were just trying to dig into the association in 2009. Somebody known from Ambala in relation, I got in touch with some boy called Rocky. He shared some papers with me regarding some A-1 land which his forefathers were in possession since 1901, which is known to the records or to him. Now we'll speak of this case. This property having survey number, I think, and plot number 398, which was designated as A1 land, was in possession of SHRIRAM Gupta. And there were some 4 buildings which were constructed on this property. And this property, original owner SHRIRAM Gupta, died in 1962 after making a will in which he gave this entire property to his wife Sarwati Devi, who further died in 1992 without making a will, and finally her 5 sons, Vijay Kumar Gupta, Saroj Gupta, Onkar Gupta, Pramod Kumar Gupta and Shakuntla Gupta. These kind of people became their pedigree. Further on, Saroj Gupta had SANJEEV Gupta and RAJEEV Gupta, and Shakuntla Gupta had Rocky Gupta and AIS. So this is the boy Rocky Gupta. Okay. So what is the whole case? The whole case stands on to that the department further issued a PP Act. It's a very peculiar case. 1957, or when the CLA rules were made and categorization of lands were done in 1927. So this property must have been given A1. Now if they were in occupation, what we just said, SHRIRAM Gupta ji, how could the property be called A1? It could have been given B3. But well, it was given A1 in the GLR, and in the testimony of the CO, a man who was in 1960 was about 90 years, if you reverse his age, Rai Bahadur Shri Chhajju Singh had said that he remembers that this building has been in existence since 1901 and prior. So, and the occupants would have been there, the building was in that same condition what must have been made in 1900. Similarly, another employee of the department who had been working for the last some 30-40 years also made that similar. In the court orders of the estate, there is very important, a plan of GLR has been tendered in 1960 of Jhansi. This is the MEO Agra is doing this. We can lay hands on this. These are the important features of these cases. A list of tenants has come forward, and very interesting, the CO says that I started charging them house tax somewhere in 55, 57. Now, 55, 57 you start doing something which was actually told to you to be done after the 1880 Cantonment Act, and the names of the tenants have been in 1959 raised to T.C. Khera, Salman Singh, Man Sukran, Anandidi, since 1935, Bhan Singh, Gurbachan Singh, S.S. Sarkar. Now, the very important part is in the pedigree, the entire notice was being worked out with the name called Vijay Kumar. Now, who's Vijay Kumar? He is one of the sons of SHRIRAM Gupta. Okay. Now, the ownership is entirely being related to him instead of the other 4 sons and their wives and their further pedigrees. So he files various cases against this PP Act under Section 5 of the Unauthorized Occupancy, which was issued in 1975. So these appeals are filed, and simultaneously the session judge would remand back the case, and finally this kept going on for about 2-3 times. So every time the case used to get remanded back, the pleading made by Vijay Sharma used to be something like the department doesn't, or the military doesn't let him attend the state court, he's not allowed to enter, and somehow. So this kept going on till 1985. 1986 again the state officer passed an order of illegal occupation. So the case was again argued, went up to Sessions Court in 1988, So what happened in 98? This time the Session Court did not remand it back. It quashed the case. And it says, look, Mr. Vijay Gupta, your lethargic habits and your uncalled calls for not attending these state courts is not to be worked at us. And finally this case goes to High Court in the form of a writ number 11480 of 1988. Now what happens in the writ? So during the Session Court there are a lot of affidavits which are tendered. I'll be reading those small because these facts came to me and I really want to know what is the status, because even in 2010 I remember I have a piece of paper which I can show you people. I had written to the bungalow owner then, Rocky Gupta, 31@yahoo.com, that please, the major points of your case are to be fought like this. But whether he did it or not, no response. Now an affidavit is given by an employee called Jagdish of the Cantonment Board. Now he says there has been an encroachment of 4,000 square feet in survey number 177. Now this property has been given a survey number, a plot number 398 or whatever earlier. And this is how. So written statements, whether given, not given. So these the entire pleadings are wrong and things like that. So he even has gone down to the extent in his affidavit stating that Mr. SHRIRAM had no powers to make a will because he was not the owner of this land in 1962 or 60 when he made the will. These are dates which are to be very important. Even there was a colonel who had Colonel Sharma, who had filed his affidavit, and in his affidavit he valued this bungalow way back in 85 to 50,000 rupees. And he said rightly the PP Act, this is A1 land, right behind the inspection bungalow. So after a lot of things. So now what happens in the High Court? The High Court very clearly says, look, you've been given n number of opportunity, you do not reach the estate court, and then you keep asking for remanding back the cases. Now you are debited a fine of 35,000 rupees and you will go to the court, file a written submission there, and then let the case start again. So this is how this High Court order is also taken on. So we have these dates now when finally the MU is writing, and these written reply comes. Now Mr. Vijay Gupta finally makes a reply, who is living in 93 Sadar Bazaar, Jhansi, Kant. He says in 1979, a miscellaneous civil appeal number 45 of 1975 filed by Vijay Kumar Gupta had been allowed by first additional district judge, and the said order dated 4th March 1975 passed by the state officer was set aside. Again on 21st January 1984, a state officer passed an order against Vijay Gupta for eviction under 5.1. A civil miscellaneous appeal number 10 of 1984 was filed by Vijay Kumar Gupta, and the same was again allowed. Fifth additional session judge, after setting aside the order, the matter was remanded back. 7th February, again the estate officer passed an eviction order, 1986, and the special judge DDA Jhansi dismissed the appeal of the Vijay Gupta. The Honorable High Court pleased to allow the civil miscellaneous petition which I just mentioned, but in this petition it was very clearly said that Vijay Gupta is going to be given an opportunity of filing a written statement and a fine of 35,000 rupees to be paid to the MEO. So these all things came up. Now here there is a pleading which is made. First, Vijay Gupta says that the MEO or the jurisdiction of the state officer does not lie on this property. One plead. Second, he pleads that PP Act, because came applicable in 1971, which he doesn't know, actually came up in 1958, was not applicable to properties which came prior to its existence from 60 years under the limitation. He is rightly saying the word 60 and everything, but the dates of the PP Acts are wrongly varied on it. So his pleadings come to the court. The department goes for a legal opinion, and the Director General makes a legal opinion. A point has risen whether the cases of encroachment on defence land which took place before September 1958 fell under the purview of Public Premises Eviction Act, and whether these could be removed under the provisional. In this connection, the advice given by the legal advisory defence is reproduced before. It is confirmed that cases of unauthorized occupation prior to 1958 can also be covered under this act, but its limitation for government is 30 years from the date of illegal action. So do we calculate this from 1958 to 30, or do we calculate this from 1975 to 30? Amazing point. You know, bungalow owners at times, they do want to get relief, they do want to take the knowledge, but you know, and unfortunately Jhansi people, we have some very learned bungalow owners like Mr. Bakshi. We can't just fight by reading these acts and sections in a piecemeal. We have to understand from 1833, when the Government of India Act actually came up, what gradually happened in 1858, Government of India Act, in 1888, and then finally, 1889, and then 1915, then 1935. So everything has to be read, and you got to pick up some judgments way back from Robinson Carey of 1865 of Barrackpur. Then only you can understand what actually is happening in these cantonments. How these old grants are gradually being converted and brought under the regime of the Cantonment Act. I'm surprised, most of the judgments, whether I'll be talking in coming, they speak of the first Cantonment Act 1910. They don't even know that the first Cantonment Act was 1864. Now, this bungalow owner, Mr. Gupta, had he taken that advice which I had sent him through mail, what was there prior to CLA rules in 1927? There is no classification of land. What was there? There was a cantonment house property registered under Rule 72, 73 and 74. We could have taken these pleadings. House Accommodation Act, if it was influxed on us in 1902. He says my bungalow was there in because there is a letter of the station commander of 1957, that in 55 they had asked for hire of this bungalow. We got to, check into our judicial record rooms, dig into the records. We can definitely lay hands. There may be some kind of lease agreement, anything. I just spoke of a case of Pune where it was the lease agreement which entirely took the case to a different level of 1923. Where is the MLR? Where is the GLR? Where is the revenue register? Schedule 1, Schedule 2, Schedule 3. Where are these written? Who's going to read these Schedules 1, Schedule 2? So everything has to be written. How did my cadastral survey number came to me? How was I given this survey number 177? If we can pick up all these points, and if I was in A1 land, do I need to get a survey number? No. No government property has a survey number. Once acquired means acquired. Why are we giving survey numbers to a government land? It's a question to be asked. So guys, in Jhansi, if people are there, just try and get into touch with this family in Pedigree. And Mr. Bakshi or anything, Mr. Fukela can do something for them. I would be enlightened. This is an amazing case. It's an irregular grant given to a bungalow owner. A similar case is there in Ambala. Similar case is there in most of the cantonments which have been Allahabad shared to me by bungalow owners, where these kind of grants were given by the cantonment executive officer, and the department then later on in 1899 and 1912 cantonment codes converted these grants into perpetual or leases in Schedule 8. Even in this bungalow, the department offered and the owner also wanted to let it get converted into, because now it is a prime location right behind the MES inspection bungalow. Maybe the army doesn't want to give you a lease. We can always get in touch. We are all old grants, never converted into new grants. Thank you.